This is Dr. David Shine, and welcome to Business Law 101. So, Chapter 18 is called Written Form. Now, one of the things I want to emphasize is I am a huge fan of put it in writing. I tell my clients this all the time, put it in writing. So this may be interesting to you, and we do want you all to understand what requires a contract to be in writing, but it doesn't override the greater principle that all good business contracts and all good personal contracts should be in writing. We shouldn't be guessing at things. The Parol Evidence Rule, and I want you to be very careful, there's no E on this, and this is not the word parole. It has nothing to do with the criminal justice system or people going home early. The Parol Evidence Rule basically says the document speaks for itself. You cannot contradict a written document by oral testimony. You have to, if you want to contradict the terms of a document, you have to introduce a writing that was done after the first document was created, a writing that amends that first document. If you don't have that, you can't testify against that document. So that's the basic principle behind the Parol Evidence Rule. Again, the easiest way to remember this is the cliche, the document speaks for itself. The document speaks for itself, meaning that you cannot introduce oral testimony to contradict a written document. Now, there are some, like anything in the law, there are going to be some different options and plays in this situation, but the key element is to be very careful what you do with the Parol Evidence Rule. Now, what we can do is key element here, any contemporaneous oral or written statements. Now, most well-written contracts have what we call an incorporation clause. An incorporation clause generally is a standard boilerplate part of a contract that says anything that we negotiated, discussed, or put together prior to the signing of this contract is in this document. If it's not in this document, it didn't happen. So that's a nice clean sweep. Now that incorporation clause usually has a second provision, and that is if you want to make any changes to this contract, you need to do it in writing, and it needs to be signed by both parties. So you've got two pieces, an incorporation clause and a disclaimer that it doesn't count if it's not signed and in writing if it changes the agreement. This is part of having well-written contracts that avoid as much as possible disputes under the Parol Evidence Rule. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.